So today we're going to talk about how to get them kids back, a child custody modification. So this one is specific to modification. If you have some questions about how it's established via like a divorce or how it's initially established, this will apply somewhat, but this is going to be specifically on how to get a modification of a parenting plan, an existing parenting plan, and then sort of how to establish a parenting plan when you have children. So keep in mind that this is specific to Tennessee. So if you're not in Tennessee, you can still contact our office. We do function in Louisiana, Tennessee, and Arkansas, but the information that I'm giving today is primarily for Tennessee, although it will roughly apply usually in some degree to other jurisdictions, but you would need to seek a licensed attorney in those jurisdictions. Okay, so first of all, in Tennessee, if there is an existing parenting plan, now that usually means that there's been a divorce and there isn't already a parenting plan in place as a provision of the divorce, so you're already operating under some agreement, or you may have been through juvenile court where the child was born out of wedlock, and you might have something you've agreed to or not. I don't know. Sometimes when it's out of wedlock, there may not be any parenting plan in existence at all. So basically, to modify visitation, it's a two-step process, okay? Step one is you have to prove there's what's called a material change in circumstance. Now, that's a legal term, material change in circumstance, and it can mean all kinds of things. Now, I have a little worksheet that I give clients to sort of help them tailor their focus on whether or not there's been a material change. And then on the second step also, if you would like a copy of that, just shoot me an email. My email's right here, and I'll be glad to send it to you for free. It's something that I made up because I've personally been there where not only have I been through the divorce trying to get as much visitation as I could, but then I've also gone back and attempted to get more visitation for various reasons. And a lot of times if you understand the law, it might help you avoid wasting money. You might be able to avoid spending money on somebody like me, on an attorney, when there might not be good reason for it. So I think it's important to understand that. So anyway, a material change in circumstance, and I've got a little head note here. I'm going to read you from a case that sort of describes it, and this is from some case law, so it's basically a judge's opinion on what a material change in circumstance is. A material change of circumstance does not require a showing of substantial risk of harm to the child. A material change of circumstance for purposes of modification of a residential parenting schedule may include, but is not limited to, significant changes in the needs of the child over time, which could be related to age, significant changes in the parent's living or working condition that significantly affect parenting, failure to adhere to the parenting plan, or other circumstances making a change in the residential parenting time in the best interest of the child. So in court, I've proven that with drug use, sometimes arrest of one party, of the other party, information like that can be a material change in circumstance. Now understand this, just because you prove, number one, that there is a material change in circumstance, it doesn't necessarily mean that you're going to get more visitation, because then you've got to go to step two and prove step two, okay? So step two is that you have to prove that a change in visitation, arguably more to you, is in the best interest of the child. And Tennessee is pretty clear on this. There are 15 factors in the statute that you have to plug specific facts from your case into these factors in the statute to show that it weighs in your favor to get more visitation. Okay, so number one, we get over the material change in circumstance, and then number two, we have to prove that a change is in the best interest of the child to where you get more visitation. And those factors, and again, it's on the handout, but I'll read you a couple of them. One is the strength, nature, and stability of the child's relationship with each parent, including whether one parent has performed the majority of the parenting responsibilities related to the daily needs of the child. Another one would be refusal to attend a court-ordered parent education seminar. The court can consider that as a lack of good faith on the part of that parent. The disposition of each parent to provide the child with food, clothing, medical care, education, and other necessary care. One that comes up in Tennessee a lot, people ask, is what is the age? Well, in Tennessee, if the child's 12 or older, the court can hear their opinion. But it is not, it doesn't mean automatically just because a 12-year-old wants to live with one parent now more than the other parent, that's not conclusive. So it by itself is just one of these 15 factors in the statute that the court can consider. There's even a catch-all in the statute that's like, just about anything else can apply. It depends. But I'll put a few up here so you can see. But just understand that that if your specific facts you're concerned with don't fit into the statute, to the factors in the statute, then you may not need to waste time on an attorney, or you at least go consult with one, and hopefully they can give you some good advice on if it's worth your time. One thing that we do is if it's not a strong case, I'm not going to waste your time. I personally went through like 3 different attorneys trying to get more visitation and some adjustments on my own thing. And hindsight, when I was the client, I really wish that I had just been told a few times, hey, don't give me any money, it's not going to apply. But that's hard for attorneys to do. But I remember being in your shoes, and so I keep that in mind, when I'm speaking with you. If it's not a good case, then I'm not going to take the case, So, but again, you can email me if you have the specific questions on that. So I think that's pretty much it on the factors. The only other thing I would say is remember this: just because it's an important factor to you, like she's cheating on you, or she's running around drinking, or he's running around, with all these questionable people. If it doesn't tie directly into those factors in the statute or have a bearing directly on the well-being of the child, it's not relevant. So, sucks, but the court doesn't care. So if you really want a modification, you've got to be able to tie these factors in, and it's so hard because it's an emotional thing when it's dealing with your children. One last thing to consider would be child support. Obviously the more visitation you get, the lower the child support can go, but just as a piece of personal advice, that doesn't need to be the reason that you go and try to get a modification. That alone is clearly not going to be enough to change it. And realistically, I don't take those cases anyway. There's usually 2 types of dads. There's the dads that want more visitation because they love their kids, and they'd even pay more for it. I was one of those dads. On the other hand, you got some dads that are just trying to get that child support lowered, And I understand, it's very stressful trying to come up with child support and pay that in addition to everything else. But when children are involved, they need to be the primary focus. Okay, so please keep that in mind as you make your decisions on what you want to do with this type of stuff. So I hope this has been beneficial. If you have specific questions, feel free to email us. Now with Gray Huffman Butler, we do have offices in 3 different states, and we're glad to help you in any of those states, Louisiana, Tennessee, or Arkansas. And of course, I hope you will like and subscribe, comment, share the video for me. I appreciate that, and then it helps me build an audience to where I can give you a little more diverse information. The next video will be on NFA trust. Those are gun trusts, so hopefully you have some interest in that. You can also find a little more information on this subject matter in my cheaper to keeper divorce video, which I want to do a follow-up on that soon too. So anyway, hope it was helpful. If you need anything, send us a message, and hopefully see you guys around. Thanks.